Start by looking at race and religion discrimination, specifically religion or belief discrimination. As you'll probably appreciate, examples of direct discrimination, so for example dismissal because of someone's religion, are relatively rare, and in practice most workplace disputes arise from religion or belief discrimination where it's an employee and the manner in which they're manifesting their beliefs that becomes the issue, and the first case looks at this.
In Grace and Places for Children, a Christian nursery manager was dismissed after colleagues complained that the way she manifested her religion at work made them feel uncomfortable and harassed. She brought a claim of direct religious discrimination, claiming that she was dismissed because of her religion. She said that she'd been discriminated against when the HR representative had told her that it was against company policy for her to hold Bible sessions with staff members, and when the managing director, Mrs. Carol Jenkins, had questioned the appropriateness of her discussions of God in the workplace, but the tribunal dismissed the claim.
The HR representative had explained to Miss Grace that while the company was prepared to allow time and a place for individuals to pray, it didn't have to facilitate group prayer sessions. She'd not said that the business was opposed to groups meeting to discuss the Bible, and there certainly wasn't any policy of restricting times when staff could discuss religious matters during breaks. The tribunal also decided that Miss Jenkins had been concerned about Miss Grace's actions and how they blurred the boundaries between work and matters which weren't work-related, and they were also having an adverse effect on the well-being of other members of staff. And so the tribunal concluded, and the Employment Appeal Tribunal also agreed, that Miss Grace wasn't dismissed because of her religion, but because of the way that she was manifesting it.
As you know, discrimination or harassment will only arise if the treatment in question is because of or related to a protected characteristic. These are sex, sexual orientation, age, race, religion or belief, gender reassignment, disability, pregnancy and maternity, and marriage and civil partnership. Caste is not included, but the government has announced plans to change this, but arguably it might not be necessary.
Well, how's that?
Well, that's because the Huntingdon Employment Tribunal last year gave a preliminary ruling suggesting that caste discrimination may already be covered by the provisions outlawing race discrimination. In Turkey and Chandok, a domestic worker claimed that because of her caste and her Christian religious beliefs, she had been underpaid and treated in a foul manner.
We did say the jokes didn't get any better.
Sorry, any opportunity to stick one in there. The employment judge refused to strike out her claim, noting that under the Equality Act, race includes ethnic origins, a concept which has a wide meaning, and they said it could arguably cover caste. This decision was appealed to the EAT, which has stated that although not a freestanding protected characteristic, elements of caste identity may in some cases form part of an individual's ethnic origin, particularly where caste is determined by descent or it contains an identifiable ethnic identity. So caste discrimination may be protected as a form of race discrimination.
Right, moving on, the next port of call is unlawful discrimination that arises from someone's belief. And the concept of belief means any religious or philosophical belief, or even a lack of one. And over the years, it's fair to say we've had a bit of fun with some of the decisions that have come out about what can or can't be classed as a belief for these purposes. The test is set out in a case called Granger and Nicholson. And essentially, the person has to have a genuinely held belief, and that's compared to a viewpoint or an opinion. And that has to be about a weighty and substantial aspect of human life, and it has to have a certain level of cogency, seriousness, cohesion, and importance. And very importantly, it also has to be a belief that's worthy of respect in a democratic society, so it mustn't conflict with the fundamental rights of others.
The Truro Employment Tribunal in Olivier and Department of Work and Pensions last year added to the wealth of case law in this area, holding that a belief in democratic socialism can amount to a philosophical belief. The tribunal held that Mr. Olivier, who was dismissed for failing to obtain his employer's permission to stand for the Labour Party in council elections and expressing his personal political opinion in the local newspaper could pursue his claim for discrimination on the ground of that belief.
We had another slightly unusual one. It was a belief that qualified for protection, but a belief in the higher purpose of public service broadcasting. And that was Mr. Maestry's claim against the BBC, which got all the way through to the Court of Appeal. But the Court of Appeal decided that his claim would have to fail because there was absolutely no evidence that his colleagues or his managers were even aware that he had that sort of belief.
Okay, we're now going to look at disability discrimination. Just to remind you, a person is disabled for employment purposes if they have a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. In our next case, Caltoft and the Municipality of Billand, the issue for the court was whether severe obesity, where a person has a body mass index of over 40, would amount to a disability for the purposes of the EU Equal Treatment Framework Directive.
And the European Court of Justice has decided that severe obesity can amount to a disability. Obesity in its own right isn't a protected characteristic, but the effects of that could still qualify as a disability. So if they prevent, for example, a worker from being able to work on an equal basis to their colleagues, or if they could only perform certain functions of their role with discomfort. And controversially, the European Court of Justice also confirmed that that would remain the case even if the person was responsible for the onset of their own obesity.
The ECJ's decision has already been relied upon by the Northern Ireland Industrial Tribunal in the case of Bickerstaff and Butcher. Mr. Bickerstaff had a body mass index of 48.5, and he worked at Randox Laboratories, where he alleged he was harassed by colleagues because of his weight. Mr. Butcher was the main perpetrator. Mr. Bickerstaff claimed that Mr. Butcher had said that he was, I quote, so fat he could hardly walk, and so fat he would hardly feel a knife being stuck into him. Relying on the ECJ's decision, the employment judge said it was satisfied that Mr. Bickerstaff had been harassed for a reason which was related to his disability, namely his morbid obesity condition.
Well, what does this case mean for you? Well, it does mean now that you're going to have to assess when a worker's obesity has reached the point where they're no longer able to perform normal day-to-day activities. And then you're going to have to consider if they're potentially suffering a disadvantage at work. So you have to think about reasonable adjustments, because an obese worker could, for these circumstances, be categorised as disabled.
As in the Butcher and Bickerstaff case, obese workers may unfortunately face inappropriate comments from colleagues about their weight, or indeed adjustments that you have to make in order to meet your obligations. So you need to be aware that this may constitute disability harassment. We therefore recommend that you update equal opportunities and anti-harassment policies to deal with this. Training on equality and diversity issues will also be very important because you want to be able to rely on the defence that you took all reasonable steps to prevent discrimination from occurring.
Well, the next case, I think it's fair to say, also tested the boundaries of EU disability discrimination law. In this case, Ms Z was born without a uterus, and so she couldn't support a pregnancy. And so she had a child via a surrogacy arrangement, but she was denied her request for leave equivalent to adoption leave. And the European Court decided that the refusal of leave didn't amount to disability discrimination, contrary to the European directive, because it said that the directive was concerned with impairments which hinder the full and effective participation of disabled people in professional life. And whilst Ms Z's condition constituted a limitation resulting from a physical impairment, and it was clearly a long-term issue, it didn't make it impossible for her to carry out normal day-to-day activities. And because of that, her condition didn't fall within the definition of disability.
A person discriminates against a disabled person if they treat them unfavourably because of something arising in consequence of their disability and cannot show that the treatment is a proportionate means of achieving a legitimate aim, in other words, justified. In crime reduction initiatives, or CRI, and Lawrence, Ms. Lawrence suffered from work-related stress and depression and was absent from work for several months. During this time, the employer's occupational health department reported that she was suffering from postnatal depression, that it was a long-term disability, and that she was not at that stage fit to either return to work or even to undertake interim duties. After she'd been absent for about 7 months, CRI decided to subject her to a capability procedure. However, in error, she was told she was required to attend a disciplinary rather than a capability meeting. She didn't attend the meeting, but it went ahead without her and she was dismissed on the ground of ill health.
Well, an employment tribunal decided that her dismissal was unfair, and because it arose from her disability, it was also a discriminatory dismissal. Although the tribunal accepted that the business's need to properly manage its workforce so that it could deliver an effective service was a legitimate aim, it decided that dismissing her wasn't a proportionate means of achieving that aim, and so because of that, the discrimination wasn't justified. The letter inviting her to a disciplinary had effectively deprived her of her opportunity to be consulted with. But the Employment Appeal Tribunal disagreed with that analysis, and they said that whilst her dismissal was procedurally unfair, it was justified. I mean, essentially what this was a mislabelling error, and the CRI, if it hadn't made the mistake that it did, and had she attended the meeting, she'd have had her opportunity to be consulted with, and the outcome would inevitably have been the same.
Okay, the duty to consider reasonable adjustments is one of the main areas where employers can get themselves into hot water. Where a working requirement, known legally as a provision, criterion or practice, or the physical features of the workplace, or a failure to provide an auxiliary aid place a disabled employee at a substantial disadvantage compared to someone who doesn't suffer from that disability, you come under a duty to take reasonable steps to try and avoid that disadvantage. An obvious example is where we've got a job applicant who's a wheelchair user. Their predecessor's office is on the first floor and there's no lift. So providing an office on the ground floor would remove the disadvantage suffered by the disability and allow that person to undertake the same work as an able-bodied person. In the vast majority of cases, that is what an employer would be expected to do, rather than just simply saying, well, they can't do their job. But what do we mean by a substantial disadvantage?
In the Crossland case, the Court of Appeal agreed with an employment tribunal that a diabetic security guard had little reasonable prospect of establishing that a requirement to carry out external patrols caused him a substantial disadvantage compared with a non-disabled person. And that was because of the fact that the risk of a hypoglycemic episode occurring during a patrol was no different than if he'd remained in the office.
For an employee to bring a claim of a failure to make reasonable adjustments or discrimination arising from disability, it's necessary that the employer actually knows about the disability, or that they could be reasonably expected to know about the disability at the relevant time. In Gallup and Newport City Council, the employee informed them that they were suffering from stress and described their symptoms as including tearfulness, nausea, inability to concentrate and headaches.
I'm going to take a stab at morning sickness.
No, it was a Mr. Gallup. The council referred him to its external occupational health advisors. And occupational health advised that the employee was suffering from work-related stress, not pregnancy, but said that they didn't think it met the test of a disability under the legislation. Whilst the council did take some steps to assist him at work, Mr. Gallup had a series of sickness absences and he was diagnosed with depression and anxiety. Yet the medical advice continued to be that he was not disabled. Ultimately, the situation led to him being dismissed following allegations of bullying.
Well, he claimed unfair dismissal, direct discrimination, and a failure to make reasonable adjustments. Whilst his claim for unfair dismissal was successful, the claim for disability discrimination failed both in the Employment Tribunal and also the EAT, because it was decided that in view of the findings of the Occupational Health Report, the council didn't know that he was disabled. But that then went to the Court of Appeal, and was overturned because they said that, yes, the employer should quite properly seek a medical opinion, but it's for the employer to make the factual judgment about whether the employee is or isn't disabled. It can't just rely on the medical opinion and then rubber stamp that.
So you might think this is a harsh decision, and it's certainly one that will catch many employers out. The case highlights the importance of asking the right questions of the medical advisors. The court said that specific practical questions should be asked which will enable an employer to form its own judgment as to whether someone might have a disability or not. And this is particularly important where, as in this case, the medical advice is that the employee is not disabled. And we'd suggest that if ever you're in any doubt, it's worth getting a second opinion.
Sex discrimination, obviously, as we've said, discrimination is often covert, so it can be very difficult to prove. And that's why we've got a shifting burden of proof rule. So if an individual can show that on the face of it, discrimination may have occurred, the burden then shifts over to the employer to disprove it. So they have to show that there was another non-discriminatory explanation for their conduct. And in the next case, an employment tribunal was criticised for approaching this test in the wrong way.
In CJD and Royal Bank of Scotland, Clyde was in a relationship with Bonnie, another employee of the bank, and shared her Glasgow flat. One evening, Clyde and Bonnie had an altercation. There were raised voices and Clyde kicked the door of the flat. He was arrested by police and charged with assault and breach of the peace. Bonnie wasn't arrested. This came to the attention of the bank, and an area manager, Mr. Lowe, called Clyde in for an interview. He claimed that Bonnie had been slapping him and punching him in the face, so in self-defence he'd pushed her onto a sofa.
Well, despite that claim, the bank suspended Clyde at the end of the interview. And Mr. Lowe then interviewed Bonnie, and she gave a significantly different version of events. She said that Clyde had, amongst other things, slapped her, grabbed her hair, pushed her head against the door, and threatened to kill her and her family. A true romantic. The bank instituted disciplinary proceedings against Clyde, and they were conducted by a different area manager, Mr. McNabney. Now, although the bank accepted that Clyde had pushed Bonnie in self-defence, he was dismissed for misconduct. Clyde claimed that that dismissal was directly discriminatory on grounds of his sex because he said that the bank had acted on the sexist assumption that in a physical dispute between a man and a woman, that the man is always the aggressor.
Clyde's argument was accepted by an employment tribunal, but the Employment Appeal Tribunal has overturned that decision. This decision was upheld by the Court of Session, which is the Court of Appeal in Scotland, which was satisfied that on the facts, the bank had not assumed that Clyde was the aggressor. In fact, to the contrary, they accepted that he had acted in self-defence. And the alleged assault was not the only reason he was dismissed. There were other factors that were taken into account. So we said at the outset that examples of direct discrimination are rare, but in a case like this, it's easy to see how stereotypical assumptions could easily be made. So make sure you don't fall into that trap.
This next case is quite interesting, for us anyway, you may disagree. But Mr. Shooter, he took 20 weeks of additional paternity leave and he was paid that at the statutory rate. But Ford had a policy of paying their female employees who took maternity leave their full basic salary for the whole period of statutory leave. And so what Mr. Shooter said was that Ford's failure to pay him on the same basis during additional paternity leave was effectively direct sex discrimination or alternatively indirect sex discrimination. And that case went to the East London Tribunal and they decided that there was no direct discrimination because the correct comparator would be a woman taking additional paternity leave. And in that set of facts, she would have received exactly the same amount, so there's no disparity. In relation to indirect discrimination, it was potentially a discriminatory requirement, but it could be justified because of Ford's need to recruit and retain women in a male-dominated workforce.
Note that additional paternity leave will be abolished on the 5th of April, and that eligible parents of babies whose expected week of childbirth either begins on or after that date, or who are placed for adoption on or after that date, will instead be entitled to take shared parental leave. Eligible employed mothers or adopters will continue to be entitled to take 52 weeks of maternity leave, and 39 weeks of either statutory maternity pay or maternity allowance, but may elect to curtail part of that leave and take the balance as shared parental leave. Now, this doesn't shorten the overall period of leave that a mother can take, but it does enable them to share it with the child's father or their partner. So this could mean taking leave at the same time or taking it in turns to have periods of leave to look after the child.
Okay, next we're going to look at the question of whether employment claims can be made if they're based on an illegal employment contract. And the situation with discrimination claims differs from unfair dismissal and contract claims. Unfair dismissal and contract claims can't proceed on an illegal contract, whereas in discrimination cases they can. In the case of Widgersundera and Heathrow, the situation here was that the AT had to decide whether a Sri Lankan national working without a valid working permit could bring claims for direct sex discrimination and sexual harassment. Ms W had been subjected to serious sexual assaults by her employer, unbelievably, during the job application process and also once she was employed.
So she took the job?
Well, incredibly, she did. But the EAT said that these incidents couldn't be said to be inextricably bound up with her failure to have a valid work permit, and there was nothing intrinsic about being an employee that led to sexual harassment. So on that basis, she could proceed with her claims of discrimination, but she couldn't claim unfair dismissal because the contract was illegal.
Protection from discrimination due to pregnancy and maternity is guaranteed under UK law under the Equality Act 2010, which prohibits unfavourable treatment on account of pregnancy or maternity, avoiding the need to identify a comparator. However, protection only applies where the unfavourable treatment occurs during what's called a protected period, and that's defined for those with the right to maternity leave as the period from the beginning of pregnancy to the end of additional maternity leave, or the date that the woman returns to work if that's earlier.
And that restriction was very important in the Lyons case. And here, Mrs. Lyons worked at the Job Centre Plus, and she fell pregnant in 2009. And at the end of that year, she was involved in a tragic accident which resulted in the death of a motorcyclist. She was obviously very shocked about that, very upset, and took some time off work. And then she started her maternity leave on the 1st of February and took 6 months ordinary maternity leave, which ended on the 1st of August, followed by a 6-week period of annual leave. And after the birth of her daughter, Mrs. Lyons was then diagnosed as suffering with moderately severe postnatal depression, and she never actually returned to work, and she was eventually dismissed in March 2011.
Mrs. Lyons brought a number of claims in the Employment Tribunal, including that her dismissal amounted to direct sex discrimination or to pregnancy and maternity discrimination. The Employment Appeal Tribunal held that although she was treated unfavourably for a pregnancy-related illness, her claim couldn't succeed because the unfavourable treatment occurred outside of the protected period. Her sex discrimination claim also failed because in accordance with EU law, an employer was permitted to take into account sickness arising in these circumstances when calculating whether absence levels justified dismissal. She wasn't treated any less favourably than a man who had taken a similar period of absence would have been treated.
This case revolved around Mrs. Kearhane, and she was a police dog handler. She had 2 narcotics dogs, and because of that, her status as dual narcotics dog handler enhanced her career prospects, and it also gave her an opportunity to earn overtime, which single dog handlers didn't get. When she announced that she was pregnant, because she couldn't be deployed on operational duties, obviously for safety reasons, the Met decided to reallocate one of her dogs, a dog called Nunky Pippin, which was her passive search dog, which left her with 1 proactive search dog. And she complained to an employment tribunal that that decision amounted to unfavourable treatment because of her pregnancy, and she then brought a second claim when the Met refused her request to have that dog returned to her before the end of her maternity leave.
An employment tribunal concluded that both the decision to take away Nunky Pippin and the subsequent decision not to reallocate the dog to her amounted to unfavourable treatment because of her pregnancy and were therefore discriminatory. The tribunal recommended that the Met amend their policy to ensure that in future, where a handler's dog is reallocated for reasons related to pregnancy or maternity leave, that reallocation is only temporary, and the dog or another dog of the same type is returned to her on resumption of operational duties following maternity leave. The Employment Appeal Tribunal has agreed that both incidents constituted pregnancy and maternity discrimination.